To Asst College of Arts and Commerce. This is Asst Edupedia. Myself, Assistant Professor Sunil Shah. Today, students, I will be covering up the topic called Introduction of the Syllabus of Mumbai University of SYBCOM under the course called Business Law, under the program called BCom, and we are making you understand the topics which are there for SYBCOM under the SEM-III and under the Unit 1 of the Business Law as this course. Students, before going to the main topic, that is the syllabus, we will be making you understand what the Bombay University expects from you. That is, what is the program outcome of this particular course, what we are learning. Under the PO1, under the Bombay University, the students, the learners, that is the students will get knowledge in the fundamentals of the commerce and deep understanding of the all courses undertaken. So students, courses means the subjects what you are undertaken, and the program means the particular what you call as the degree what you are gaining. Here in this case we would be speaking about the program called BCom. Under that, which is we are learning SYBCom. What is the PO2? That is the program outcome 2. The students or the learners will be equipped to join the industry or set up own entities, pursue further professional and other courses. That means the students, after understanding through these particular courses, they will be setting up their own industries or setting their own startups, or will go for higher education. What is the program outcome 2, which has been specified according to the Mumbai University. Under the PO3, that is the program outcome 3, the learners will be equipped to face upcoming challenges by gaining different knowledge from the different courses from the industries and the business, as the specialization offered exposes them to practical aspects. The students will be learning more of practical aspects, that is the accounts, and would be learning more of theoretical parts related to economics or business communication or the human resource. Under the program outcome 4, that is PO4, the learners will be responsible citizens because they would be running environmental studies in their different programs, and also the various academic and co-curricular courses imbue sensitivity, the moral and ethical values among the different courses. So students from this particular program, the students will be also a responsible citizen also. Today in this particular video, I would make you understand about the course outcome of my subject, that is called Business Law. What we are expecting the students to be gaining after learning this particular course called Business Law. The course outcome, that is the CO1, the students will be able to understand the framework of the business law in India with the study of the Indian Contract Act. So as you are aware, from day in and day out, the peoples are having a contract with one another, whether you are using the electricity or whether you are appearing for the exams in the classes, we are having a contractual relationship between them. When you are taking the admission also, we are having the contractual relationship. That means we are learning more of Indian Contract Act under the course outcome 1. Under the course outcome 2, the students are oriented to learn with the basic concept like contract. Special contracts would be specifying of the law of agency, bailment or indemnity, or the law of guarantee, or they would be learning of the Sales of Goods Act and the Negotiable Instrument Act, along with the case laws which are been cited in the courses. Under the course 3, that is the course outcome 3, the students will be able to understand the relevance of the law to the individuals, whether what we are learning with the outdated laws and the new laws which are been done. Students will be also learning about the amendments in the different laws, whether it is Indian Contract Act or law of indemnity or in the Negotiable Instrument Act 1881. Under the course outcome 4, the students will be also understand the laws related to consumer protection, which is done in the other what you call as the semester. So students, under the unit 1 will be more specifically speaking, unit 1, unit 2 and unit 3 speaks about the contract. So students, we are aware what does the contract means. There should be offer from one side, there should be acceptance from other side. The offer plus acceptance is equal to agreement. Agreement supported by the consultation or enforceability by law would be called as contract. So when the students break the contract, what are the laws related to them, and when the students are being binding into the contracts, which are the laws affected to make the citizen responsible. So under unit 2, we will be speaking about more about the Indian Contract Act 1872, part 2, that is the consent. We will speak on the consent, when the consent is said to be free. When the consent is said to be free, one is free from violation, one is coercion, undue influence, fraud, misrepresentation or mistake of law and the mistake of fact. So when the person is giving the consent to other person, he should make his mind clear and his intention to entering into the contract, and also would be speaking about the agreement which are in which the consent is not said to be free. These are the 5 elements where the consent are said to be free. One is coercion, undue influence, misrepresentation and mistake of law and fact. Well, students will also make you understand under the section 24 to section 30 of the Indian Contract Act related to void agreements, will make you a concept clear what do you mean by void agreements and when the agreements are valid and what is the difference between the void agreement and the valid agreement. Under the section 31 and under section 68 to 62 would be making you understand about the contingent contract and the quasi contract. As the word means, contingent means happening or non-happening of the event. So whenever the person enters into contract, when this certain things or certainties happens, then it would be called as contingent, and if it is not happening also, it would be called as contingent contract. And the type of other different contract would be called as quasi contract. Quasi contract are those contracts where it is unwritten form of contract, that is more related in section 68 to section 72 of the Indian Contract Act. Also students, the new concept when we are entering to the digital era, where we buy something online, when we order for medicine, garments, or we do anything like payment, that would be more related to e-contracts, which is make you understand about the e-contracts and the legal issues in the formation and discharge of e-contract. And the concept of performance of the contract would be more related in section 37. So students, also we would be learning about the modes of revocation of the contract or the modes of discharge of the contract and the remedies on the breach of contract. What are the legal rules related to the breach of the contract? Students, under the unit 1 would be speaking about the contract, the definition of the contract, the essential elements of the valid contract, and the classification of the contract. So students, please remember what are the essential elements of the contract. It would be offer, acceptance, intention to create legal relationship, capacity, possibility of performance, and would be having called as legal object and the legal certainties for entering into the contract, and what are the contracts which are called as contingent and non-contingent contracts, which have been classified into the types of contract. So under the classification of contract would be having void contract, voidable contract, the valid contract, then would be calling as simple contract or agreement unenforceable by the law, and would be implied, express, or executed contract, which would be learned by the students. Also would be making you understand what even by offer, what are the conditions laid with the offer, and how the offer should be acceptance, and what are the conditions related to acceptance, whether it is oral or implied acceptance. Rules for the valid offer and the valid acceptance would be also made you understand. And when a person is buying something and when the person is also arguing for the rate, then that would be called as a counter offer. So making you understand about the counter offer, when the one party offers and the other party makes a counter offer, that would be also made you understand. Also for the open offer, and distinguish between the offer and the invitation to offer. So whenever the e-companies like the commerce companies, when they do online sale on the website, that would be called as invitation to the offer, and that is not, it is invitation to each and everyone, not to the single person. So when a person comes out with the tender, that would is called as open offer. And the concept of communication, whether the offer should be completed by giving the communication by writing or through oral, it would be called as completion of the contract. And also what are the rules related to revocation of the offer, or if you want to cancel that particular offer, or if you want to cancel that particular acceptance, that would be called as revocation, which is more specified under section 3 and section 5. Students, the main part about the Indian contract is the capacity. The capacity means the ability to understand the things of the contract. The terms and conditions of the contract is called as the capacity of the contract. So the person who is insane, lunatic, or the person who has been insolvent cannot enter into the contract. So these particulars are being not allowed to enter into the contract, whether it is minor, unsound mind, or the person who have been disqualified by law. Okay, they cannot enter into the contract. That is, those persons who are in the state of intoxication, or those persons who are in coma, they are not able to enter into contract. Students would be making you understand under section 2 and section 25 about the main term, that is called consideration. So for offer, acceptance, that is agreement plus consideration is the main crux. And we will be speaking about the consideration under section 2 and section 25 of the Indian Contract Act, making your concept clear about the consideration, the importance of consideration, the legal rules of the consideration, and the exemptions where consideration is not necessary, which is more specifically spoken about section 25, where consideration is not at all mandatory when we make a gift, or there are some consideration which are unlawful, would be made you explain under section 23. Coming to the unit 3, we would be speaking about the main parts, that is called indemnity, law of agency, bailment, pledge, and the contract of guarantee. So these are called as special contracts when they are having an agreement between the two persons. Would be having the law of agency, the law of bailment, the law of guarantee, and the law of pledge would be made you understand under this special contract under the unit 3. Law of indemnity is means that the person should be protected from the loss. So when when the share certificate or the living certificate has been lost, we give it in writing to the particular authority, and that particular authority makes you write on the stamp paper, that is called as a bond. So what type of contract is that is we called as law of indemnity, is to protect or to save from the other person from the loss, will be called as law of indemnity, would be explained you under unit 3. Also would be making you understand about the law of guarantee under section 124 and 125 of the Indian Contract Act, followed with 126 and 127 and 129 of Indian Contract Act, and following with the types of called as guarantee under 132 to 147 of the Indian Contract Act. The concept, the essential and some elements of indemnity, the law of guarantee, that means when a person enters into the contract with the bank, then the banks ask for the surety, that would be called as law of guarantee, and the person would, the principal or the creditor or the debtor, the principal creditor or the debtor or the surety or the third party, that guarantor, what is his rules, what are the rules regarding to that would be more explained under law of guarantee. Coming to the main part, that is called law of bailment under section 148. What this, that is means I am giving my temporary goods to the tailor or to the garage wala to convert my shirt piece into the shirt, or if I want to repair my bikes or a scooter or my what you call a cell phone. So that would be giving my goods to the other person for temporary period. That would be more explained under the bailment. If I am giving my gold bar or the gold biscuits to convert into Mangalsutra or to bangles, that means I am giving my goods for temporary period, would be more learnt under the terms called bailment. Followed with the concepts of the bailment, kinds of bailment, what are they called as gratuitous bailment, what would be called as non-gratuitous bailment, where the money is not been involved, that would be called as non-gratuitous bailment, would be more clear. And the main part would be related to the duties and the rights of the bailer and the bailee. Coming to the another part of the special contract would be pledge. That means I am giving my temporary goods to some other person, and on behalf of that particular person I am taking that particular consideration. That is not I am asking that to return the goods, assigning some work, but I am giving that particular custody for temporary period, that is I am asking some money, that would be called as pledge. So I would be making you understand what are the rules of the pawner and the pawnee. That means I am giving the goods for temporary period, and mortgage is something different. Mortgage is I am giving some goods, immovable property for that particular period, and after that if I am not able to complete with the terms and conditions as mentioned in the mortgage or the pledge, they can have the right to dispose of according to the terms and conditions of the contract. Speaking about the law of agency, when I am the distributor of the Patanjali or if I am distributor of the Colgate, what are the rules related to the principal agencies? That means I should sell my own goods according to the terms and conditions, and I should also show my the book of accounts, and I should be able to explain to my principal, that would be informed under the law of agency, the concept, the modes of creating the agency, the way in which the termination of the agencies, and the rights and duties of the principal and agent would be more explained under unit 3. So students, under unit 3 would be speaking of law of indemnity and law of guarantee, followed with bailment, followed with pledge and law of agency. Coming to the second last part, that is called unit 4, we would be speaking of the Sales of Goods Act 1930. Under Sales of Goods Act, we would be speaking about the contract of sale, what are the essential of sale, that is called there should be two parties, there should be money consideration, there should be absolute or what called as conditional sale, and all the essential elements of the valid contract should be present under the sale. Students, I would be making you understand between the sale and agreement to sale and also the hire purchase agreement. So there are two terms which are totally different, that is called sale, that is called after the completion of that particular thing, buying and selling. Agreement to sell, that means I am making an agreement to sell that goods, that is our separate concept. Also would be making you understand between the types of goods, that is anything above the earth would be classified under Sales of Goods Act, what we call future good or certain goods or certain goods, and also the goods, the law which is applicable for the destruction of the goods or due to this what we call the rainfall or the natural calamities, what would be the rules regarding to the destruction of the goods. We will be speaking about more about the conditions which are being specified when there is a sale, and the warranties which are being assigned to them, which is more explained under section 11 to section 25 and section 62 to 63 of the Sales of Goods Act, and also making the concept clear with the distinguish between the conditions and the warranty. Condition warranties also would be making explain the doctrine, which is very important under the examination, which has been classified, which have been asked in also always in BCom, this particular program or CS or CS. They would be making you understand about the doctrine of caveat emptor. What does the doctrine of caveat emptor makes you understand? That means the buyer should be totally aware of the goods, a buyer should be keeping his brain and eyes open when he is buying some goods. So for petty offenses, you cannot go into the court of law and ask for the justice. When you are buying the vegetables, it means you should keep your eyes and brains open while buying the goods. We should not rely with on the seller's skills and judgment. This seller's skill when he's selling the goods. That means we should keep your eyes open. But there are some exceptions related to them. So making you understand under the doctrine of caveat emptor. Also, we will be speaking of the property, the concept, rules of transfer of property under section 18 to section 26 of the Sales of Goods Act. Students, the last and concluding part under the unit 4 would be what are the rights of unpaid seller, would be under section 45 to 54, that is the concept, rights of the duties of the unpaid seller, the remedies for the breach of contract of the sale, and also make you understand with the latest topic, that is called auction sale, what do you mean by knockout agreement, what do you mean by bidding, and what do you mean by not bidding. Students, under unit 5 we have Negotiable Instrument Act 1881. Under Negotiable Instrument 1881, I would be making you understand the concept of the characteristic, the classification of negotiable instrument, and the maturity. Also, we will be learning of promissory note or bill of exchange, and the concept of promissory note and the bill of exchange, including the kinds of promissory note and bill of exchange. Students would be making you understand about the types of checks, the crossing, different types of check, and what even were the features of CTS 2010, the different type of checks, also with the cases where the check have been bounced or returned by the bank. That would be under section 138, what are the protection given to the bankers and how the person would be liable when the checks have been bounced with the latest amendments. Also, the role of the notary public under when the check are been bounced. Students, would be making you understand about the paper pattern. Bombay University, under the program called BCom, under the course called Business Law, the paper pattern is something different. We are having only and only theoretical questions. We don't have any objectives. So the paper pattern of Mumbai University under the course called Business Law under the SEM-III, it would be of 100 marks paper, and in one question there would be, in one question, a question paper consists of 5 questions. Under the question number 1, we would be having 4 sub questions. Under the 4 sub questions, you have to answer any 2. That is, any 2 out of 4, 10 marks is, that is 20 marks into 5 questions would be called as 100 marks. All the questions are compulsory. We are having an internal choice. Each question have to have a sub question of 10 marks each, and student has to answer 2 out of 4. So this is the paper pattern. So students, business law paper pattern is only and only theoretical. 20 marks each question into 5 questions, that is called as 100 marks. In 20 marks, that is one question from each unit, that is from unit 1, unit 2, unit 3, unit 4 and unit 5. There would be one question of 20 marks, and under one question there would be 4 sub question, and from 4 sub question you have to answer any 2. Thank you from my side, students. In this particular first video which I am sharing you is the question paper pattern, the syllabus of SYBCOM program under the course called Business Law. Thank you from my side.